Okay, we are back on the record. Could all of you pass your notebooks down towards Deputy Benz, please? So when you were last here, the state rested, subject to rebuttal. Does the defense intend to present any case?
No witnesses, Your Honor.
Then at this point in time, I'm deeming the evidence closed. So here's the plan for the afternoon. It is 3:05. I'm going to read to you the instructions, and then we're going to go into closing arguments. I've set time limits because I think it'll help on this case. So each side will have in total a maximum of 45 minutes to utilize during their closings. That's going to get us pretty close to 5 o'clock, and then we'll come back tomorrow for deliberations, okay? So, members of the jury, I will now instruct you upon the principles of law, which you are to follow in considering the evidence and in reaching your verdicts. It is your duty to follow all of these instructions. Regardless of any opinion that you might have about what the law is or ought to be, you must base your verdict on the law that I give to you in these instructions. Apply the law to the facts in this case which have been properly proven by the evidence. Consider only the evidence received during this trial and the law that I give to you in coming to your conclusions and your verdict in this case. If any member of this jury has an impression of my opinion as to whether the defendant is guilty or not guilty, you should disregard that impression entirely and decide the issues of fact solely as you view the evidence. You, the jury, are the sole judges of the facts, and I am the judge of the law only. Now, the first count of the information in this case charges that Maxwell Anderson, on or about Tuesday, April 2nd of 2024, in Milwaukee County, did cause the death of Sade Robinson, another human being, with the intent to kill that person, contrary to Wisconsin statutes. To this charge, the defendant has entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. The defendant in this case is charged with first-degree intentional homicide, and you must first consider whether the defendant is guilty of that offense. If you're not satisfied that the defendant is guilty of first-degree intentional homicide, you must consider whether the defendant is guilty of first-degree reckless homicide, which is a less serious degree of criminal homicide. Now, the crime referred to as first-degree intentional and first-degree reckless homicide are different types of homicide. Homicide is the taking of to kill. First-degree reckless homicide requires that the defendant acted recklessly under circumstances which showed utter disregard for human life. It is for you to decide of what type of homicide the defendant is guilty, if guilty at all, according to the instructions which define the two offenses. Now, first-degree intentional homicide is defined in 940.01 of our criminal code and is committed by one who causes the death of another human being with the intent to kill that person or another. Before you may find the defendant guilty of first-degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. One, that the defendant caused the death of Sade Robinson. Cause means that the defendant's act was a substantial factor in producing the death. Two, that the defendant acted with the intent to kill Sade Robinson. Intent to kill means that the defendant had the mental purpose to take the life of another human being or was aware that his conduct was practically certain to cause the death of another human being. While the law requires that the defendant acted with the intent to kill, it does not require that the intent exists for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even for a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. You cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all of the facts and circumstances in this case bearing upon intent. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of the defendant in order to convict. Evidence of motive by itself does not establish guilt. You should give it the weight you believe it deserves under all of the circumstances. If you're satisfied beyond a reasonable doubt that the defendant caused the death of Sade Robinson with the intent to kill, you should find the defendant guilty of first-degree intentional homicide. If you're not so satisfied, you must find the defendant not guilty of first-degree intentional homicide, and you should consider whether the defendant is guilty of first-degree reckless homicide in violation of statutory section 940.02 sub 1, which is a lesser included offense of first-degree intentional homicide. You should make every reasonable effort to agree unanimously on the charge of first-degree intentional homicide before considering the offense of first-degree reckless homicide. However, if after full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of first-degree intentional homicide, you should consider whether the defendant is guilty of first-degree reckless homicide. Now, as I already stated, first-degree reckless homicide is defined in 940.02 sub 1 of our criminal code and is committed by one who recklessly causes the death of another human being under circumstances that show utter disregard for human life. Before you may find the defendant guilty of first-degree reckless homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. One, that the defendant caused the death of Sade Robinson. Cause means the defendant's act was a substantial factor in producing the death. Two, that the defendant caused the death by criminally reckless conduct. Criminally reckless conduct means that the conduct created a risk of death or great bodily harm to another person, and the risk of death or great bodily harm was unreasonable and substantial, and that the defendant was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. The third element is that the circumstances of the defendant's conduct showed utter disregard for human life. In determining whether the circumstances of the conduct showed utter disregard for human life, consider these factors: what the defendant was doing, why the defendant was engaged in that conduct, how dangerous the conduct was, how obvious the danger was, whether the conduct showed any regard for life, and all the other facts and circumstances relating to the conduct. Consider also the defendant's conduct after the death, to the extent that it helps you decide whether or not the circumstances showed utter disregard for human life at the time that the death occurred. If you're satisfied beyond a reasonable doubt that the defendant caused the death of Sade Robinson by criminally reckless conduct, and the circumstances of the conduct showed utter disregard for human life, you should find the defendant guilty of first-degree reckless homicide. If you're not so satisfied, you must find the defendant not guilty. You are not in any event to find the defendant guilty of more than one of these offenses. Now, the second count of the information in this case charges that Maxwell Anderson, on or about Tuesday, April 2nd of 2024, in Milwaukee County, Wisconsin, did dismember a corpse with the intent to conceal a crime, contrary to Wisconsin statutes. To this charge, the defendant has also entered a plea of not guilty, which means the state must prove every element of this offense charge beyond a reasonable doubt. Section 940.11 sub 1 of our criminal code is violated by one who mutilates, disfigures, or dismembers a corpse with the intent to conceal a crime or avoid apprehension, prosecution, or conviction for a crime. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. One, that the defendant dismembered a corpse. Two, that the defendant dismembered a corpse with the intent to conceal a crime. This requires that the defendant acted with the purpose to conceal a crime. You cannot look into a person's mind to find intent. Intent must be found, if found at all, from the defendant's acts, words, statements, if any, and from all of the facts and circumstances in the case bearing upon intent. If you're satisfied beyond a reasonable doubt that both elements of this offense have been proved, you should find the defendant guilty. If you're not so satisfied, you must find the defendant not guilty. Now, the third count in the information in this case charges that Maxwell Anderson, on or about Tuesday, April 2nd of 2024, at 2926 West Lisbon Avenue in the city of Milwaukee, Milwaukee County, Wisconsin, by means of fire, did intentionally damage the property other than a building of Sade Robinson, valued at $100 or more without that person's consent, contrary to Wisconsin statutes. To this charge, again, the defendant has entered a plea of not guilty, which means the state must prove every element of this offense charged beyond a reasonable doubt. Arson is defined in 943.03 of our criminal code and is committed by one who, by means of fire, intentionally damages any property of another without that person's consent if the property is not a building and has a value of $100 or more. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following 5 elements were present. Number 1, that the defendant intentionally damaged a 2020 Honda Civic by means of fire. Damage means injured, charred, defaced, and includes smoke damage. Intentionally means that the defendant must have had the mental purpose to damage the property of another by means of fire, or was aware that his conduct was practically certain to cause the damage to the property. The second element is that the 2020 Honda Civic was the property of another. Property of another means property in which a person other than the defendant has a legal interest, which the defendant has no right to defeat or impair, even though the defendant may also have a legal interest in the property. The third element is that the defendant damaged the property by fire without the owner's consent. The fourth element is the value of the 2020 Honda Civic was $100 or more. And the fifth element is that the defendant knew that the 2020 Honda Civic belonged to another person, and that the other person did not consent to the damage of the property, and that the value of the property was $100 or more. Again, you cannot look into a person's mind to find intent and knowledge. Intent and knowledge must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all of the facts and circumstances in the case which bear upon intent and knowledge. If you're satisfied beyond a reasonable doubt that all 5 elements of this offense have been proved, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. The fourth count in the information charges that Maxwell Anderson, on or about Tuesday, April 2nd, 2024, in Milwaukee County, Wisconsin, did hide a corpse with the intent to conceal a crime contrary to Wisconsin statutes. To this charge, again, the defendant has entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. Section 940.11 sub 2 of our criminal code is violated by one who hides or buries a corpse with the intent to conceal a crime. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following 2 elements were present. 1, that the defendant hid a corpse. 2, that the defendant hid a corpse with the intent to conceal a crime. Can't look into a person's mind to find intent. Intent must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all of the facts and circumstances in the case bearing upon intent. If you're satisfied beyond a reasonable doubt that both elements of this offense have been proved, you should find the defendant guilty. If you're not so satisfied, you must find the defendant not guilty. Now, evidence is, first, the sworn testimony of witnesses, both on direct and cross-examination, regardless of who calls a witness. Second, the exhibits the court receives, whether or not they go to the jury room. Third, any facts to which the lawyers have agreed or stipulated, or which I've directed you to find. Anything you have seen or heard outside of this courtroom is not evidence. You are to decide this case solely on the evidence offered and received at trial. Disregard entirely any question that I did not allow to be answered. Do not guess at what a witness's answer might have been. If a question itself suggested certain information might be true, ignore the suggestion and do not even consider it as evidence. Attorneys for each side have the right and the duty to object to what they consider are improper questions asked of witnesses and to the admission of other evidence which they believe is not properly admissible. You should not draw any conclusion from the fact that an objection was made. By allowing testimony or other evidence to be received over the objection of counsel, I am not indicating any opinion about the evidence. You jurors are the judges of the credibility of the witnesses and of the weight of the evidence. During the trial, I have ordered certain testimony to be stricken. Disregard all stricken testimony. Remarks of the attorneys are not evidence. If a remark suggested certain facts not in evidence, disregard the suggestion. It is not necessary that every fact be proved directly by a witness or an exhibit. A fact may be proved indirectly by circumstantial evidence. Circumstantial evidence is evidence from which a jury may logically find other facts according to common knowledge and experience. Circumstantial evidence is not necessarily better or worse than direct evidence. Either type of evidence can prove a fact. Whether evidence is direct or circumstantial, it must satisfy you beyond a reasonable doubt that the defendant committed the offense before you may find the defendant guilty. Evidence has been presented relating to the defendant's conduct after an alleged crime was committed. Whether the evidence shows consciousness of guilt and whether consciousness of guilt shows actual guilt are matters exclusively for you to decide. The weight of evidence does not depend on the number of witnesses on each side. You may find that the testimony of one witness is entitled to greater weight than that of another witness or even of several other witnesses. In weighing the evidence, you may take into account matters of your common knowledge and your observations and experiences in the affairs of life. Ordinarily, a witness may only testify about facts. However, a witness with specialized knowledge in a particular field may give an opinion in that field. In determining the weight to give to this opinion, you should consider the qualifications and credibility of the witness, the facts upon which an opinion is based, and the reasons given for the opinion. Opinion evidence was received to help you reach a conclusion. However, you are not bound by any witness's opinion. The identification of the defendant is an issue in this case, and you should give it your careful attention. You should consider the reliability of any identification made by a witness, whether made in or out of court. You should consider the credibility of a witness making an identification of the defendant in the same way you consider credibility of any other witness. Identification evidence involves an expression of belief or impression by a witness. Its value depends on the opportunity the witness had to observe the offender at the time of the offense and later to make a reliable identification. Consider a witness's opportunity for observation, how long the observation lasted, how close a witness was, the lighting, the mental state of the witness at the time, the physical ability of the witness to see and hear events, and any other circumstances of the observation. You should also consider the period of time which elapses between a witness's observation and the identification of the defendant, and any intervening events which may have affected or influenced the identification. In evaluating the identification evidence, you are to consider those factors which might affect human perception and memory and all the influences and circumstances relating to the identification. Then give the evidence the weight you believe it should receive. If you find that the crime alleged was committed, before you may find the defendant guilty, you must be satisfied beyond a reasonable doubt that the defendant is the person who committed the crime. Ordinarily, a witness may testify only about facts. However, in this case, Detective Casey Donahue was allowed to give an opinion as to what he heard on a video-audio recording. In determining the weight you give to this opinion, you should consider the witness's opportunity to observe what happened and the extent to which the opinion is based on that observation. Opinion evidence was received to help you reach a conclusion. However, you are not bound by the opinion of any witness. During the trial, a witness was told to assume certain facts and then was asked for an opinion based upon that assumption. This is called a hypothetical question. The opinion does not establish the truth of the facts upon which it is based. Consider the opinion only if you believe the assumed facts upon which it was based have been proved. If you find that the facts stated in the hypothetical question have not been proved, then the opinion based on those facts should not be given any weight. A defendant in a criminal case has the absolute constitutional right not to testify. The defendant's decision not to testify must not be considered by you in any way and must not influence your verdict in any manner. It is the duty of the jury to scrutinize and to weigh the testimony of witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is the believability of the witnesses and the weight to be given to their testimony. In your determination of credibility, you must avoid bias, conscious or unconscious, based on a witness's race, national origin, religion, age, ability, gender identity, sexual orientation, education, income level, or any other personal characteristic. In determining the credibility of each witness and the weight you give to the testimony of each witness, consider these factors. Whether the witness has an interest or lack of interest in the result of the trial, the witness's conduct, appearance, and demeanor on the witness stand, the clearness or the lack of clearness of the witness's recollection, the opportunity the witness had for observing and for knowing the matters the witness testified about, the reasonableness of the witness's testimony, the apparent intelligence of the witness, bias or prejudice, if any's been shown, possible motives for falsifying testimony, and all other facts and circumstances during the trial which tend either to support or to discredit the testimony. Then give to the testimony of each witness the weight you believe it should receive. There is no magic way for you to evaluate the testimony. Instead, you should use your common sense and experience. In everyday life, you determine for yourselves the reliability of things people say to you, and you should do the same thing here. In reaching your verdict, examine the evidence with care and caution. Act with judgment, reason, and prudence. Defendants are not required to prove their innocence. The law presumes every person charged with the commission of an offense to be innocent. This presumption requires a finding of not guilty, unless in your deliberations you find it is overcome by evidence that satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you can return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with the defendant's innocence, you must do so and return a verdict of not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs in life. A reasonable doubt is not a doubt which is based on mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. While it is your duty to give the defendant the benefit of every reasonable doubt, you are not to search for doubt. You are to search for the truth. Consider carefully the closing arguments of the attorneys, but their arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence under the instructions that I have given to you. State, are you prepared to proceed?
Yes.
Please do so.
Ladies and gentlemen, at the beginning of this trial, I told you that I was going to ask you to do two things then. I'm asking you to do the same two things now, and it's use your common sense and search for the truth. That is what the bulk of those instructions are telling you to do. You have heard all of the evidence in this case. You have heard from dozens of witnesses. You have seen hundreds of images, watched stacks of videos. You are fully equipped to determine what the facts are, what it is that happened on April 1st and April 2nd. All of that information has rendered you capable of rendering fair and rational verdicts. And the judge has instructed you on the law, and shortly, probably not today, but when you come back tomorrow, it's going to be your time to let your voice heard after hearing everything that you have heard. On the night of April 1st, 2024, into April 2nd, 2024, Sade Robinson was murdered. She was taken to Warnemont Park, cut into pieces, dispersed mostly into Lake Michigan. Her car taken to Warnemont Park, cut into pieces, dispersed mostly into Lake Michigan. Her car taken to the north side of Milwaukee and burned behind an abandoned building at 30th and Lisbon. And the evidence in this case has shown you beyond a reasonable doubt that the individual responsible for those intentional acts is Maxwell Anderson. This is my opportunity to summarize the evidence for you, and I'm gonna do it in kind of essentially the form of a timeline on the TV screen here. So we'll start out with Sade's day. And Sade Robinson, she was a 19-year-old young woman just coming into adulthood. She was anything and everything that any 19-year-old would want to be. She worked a job. She worked two jobs. She went to MATC. She was supporting herself. She had her small Lower East Side apartment, modest. And most of all, she was loved and respected by her family. She was fun, social, and clearly anybody knew her cared about her deeply until she came into contact with 33-year-old Maxwell Anderson. At 9 a.m., April 1st, Sade left her apartment at 1858 North Commerce Street. She is wearing the last clothes she would ever wear, that white cable knit top, the black puffy coat, the ripped jeans, and the white shoes. And she went to work at Pizza Shuttle. She arrived at Pizza Shuttle over there on North Farwell Avenue on the Lower East Side around 9:15 a.m., and she worked her shift, just like any other day of her life. Beginning around 4:15 p.m., she began texting with Maxwell Anderson. They had met the previous weekend at Victor's. You saw the video of her going into Victor's and then him walking her out. And it's clear that they were intending to meet up that night. And Maxwell Anderson says, why not Twisted Fisherman? And this text conversation begins around 4:15 p.m., and they agree to meet there shortly after 5 p.m. We know from the cellular records where each of them are at those times. Maxwell Anderson is over at his house on South 39th Street, and Sade is up here at Twisted Fisherman. When her shift is over, she goes to meet him at the Twisted Fisherman. Maxwell Anderson takes an Uber ride. Sade leaves work at 5, and the phone information shows them both moving towards the Twisted Fisherman right around the same time. And we know that Maxwell Anderson walks in to the Twisted Fisherman at 5:09 p.m. wearing that black Carhartt shirt that would later be found in his laundry, and the red plaid jacket that police found inside Maxwell Anderson's house that you know has Sade Robinson's DNA on it and Maxwell Anderson's DNA on it. 5:11, 2 minutes after he gets there, he sits down at the bar, he sends a text to Sade, just got to Twisted. Sade arrives around 5:20. We know that from about 5:20 p.m. to 6:24 p.m., the two of them sit at Twisted Fisherman. They eat, they have some drinks. They both take shots. In fact, at one point, Sade turns down a shot, but they're just hanging out. And after 6:24 p.m., the two of them leave Twisted Fisherman together. They walk out and they walk together to Sade Robinson's 2020 Honda Civic that she has driven there. Sade drives the two of them from Twisted Fisherman to Dukes on Water. We know they travel to Dukes on Water between 6:24 p.m., arriving there just around 6:33 p.m., and you saw the video of them parking. Sade, again, driving, Maxwell Anderson riding passenger, just the two of them. They walk into Dukes on Water at 6:36 p.m., consistent with the phone information showing them arrive at Dukes on Water at 6:36 p.m. At 9:03 p.m., actually, I'll go back up. They stay there. They hang out right here. Maxwell Anderson is drinking. He's having multiple drinks. Sade's got a couple drinks. Mr. Anderson takes it upon himself to play a few games of bar dice, and he takes several shots. But at no point at any time when they're at Twisted Fisherman or Dukes on Water is Sade Robinson doing anything that comes close to excessive drinking or anything like that. In fact, when you watch her on these videos, she is totally coherent. She has her wits about her. When they leave at 9:03 p.m., she's fine. They walk out together. She's not stumbling. She's totally fine. They walk together to her car. She gets in the driver's seat, and he gets in the passenger seat, and it's just the two of them who leave the bar together. And ladies and gentlemen, this video right here that's playing on the screen and the surrounding videos that watch Sade going into her car, this is the last time Sade Robinson was in public with anybody else. That young lady who's in Dukes, who she gives a hug to at the end of the night when they're leaving, that's the last person other than the defendant who she was with, who she had contact with. That's what the evidence shows. After this time, they leave, and we know exactly what route they took. Through the videos from downtown, they drove Sade Robinson driving, Mr. Anderson riding passenger. They take McKinley up. They get on the interstate. They drive to the south side. This is occurring from 9:04 to 9:14 p.m. By 9:14 to 9:25, they're getting off the interstate, heading Westbound on Morgan Avenue, it's the Holt Avenue exit, but it's Morgan Avenue to the west of the interstate. And they go and they arrive at his residence just around 9:20 to 9:25 p.m. That's what the phone records confirm. And that is what the videos, here's one of them from around Sade's residence, show as well. You had the videos of them pulling into the alley. All of this confirming, by the way, that Sade Robinson's phone is essentially wherever her car is that night, right? It's at Pizza Shuttle when she's working, it's at Twisted Fisherman when she's there, and it goes back to her with Maxwell Anderson after they leave Duke's. And they don't stop anywhere. Remember that. When they leave Duke's, they don't stop anywhere. It's a continuous trip on that Life 360 app from Duke's to Mr. Anderson's home, and they arrive there at 9:20 p.m. And we know that after 9:20 p.m., 9:23, this is that really small video that shows them coming into his backyard at 9:24 p.m. She has parked her car in the alley, just the two of them, and they come inside at 9:24. And by 9:25 p.m., they are upstairs. That motion light is on. And you heard from the detective who watched this video for hundreds of hours. You saw a lot of the clips from here overnight, some of them pretty cumbersome, but what did that establish that happened? It established that they were both there in Maxwell Anderson's apartment, and there is constant movement coming from that upstairs front window, starting at 9:25 p.m. when they're up there and going essentially on and off all the way up until 12:45 a.m., at which time all movement at that house, in that front window, and in that backyard by that back gate stops. What else happens in that time? You see movement beginning at 11:24 p.m. in the side yard. Here's the slide that shows their phones remaining there, corroborating what the video shows of her car arriving there as well. At 11:25 p.m., we see that movement in the side yard beginning. Then there's movement again after 11:25 p.m. on and off in that above front room. 12:05 to 12:08 a.m., what do we know is happening? We know that Maxwell Anderson is on his phone, traversing his photo gallery, where he has, by 12:05, already acquired pictures, already taken pictures of Sade Robinson incapacitated on his couch. She is face down. Her face is buried in his couch cushion. He has her breast exposed, and he is grabbing her right breast, the breast that would later be cut off of her body, and pulling her pants down. And you know from the search warrant of the house, this right here is that brown ottoman, this right here is the red couch. Between the movement in that front window and these photographs, you know that Sade Robinson became incapacitated while she was in that front room of Maxwell Anderson's house, laying on his couch, face down. She is out of it there. Out of it. He is grabbing her because he knows he can, because she's not going to do anything about it. She has no power. You can see that in those photos. Her face down in the cushions. 12:44 a.m., this is the last movement in that side yard. And if you recall, I made it a point to ask about the two blinking lights from her car, the Honda Civic. You saw it in the video from when they left Duke's on Water, and you see it in this video from across the street. It's faint, but it's there. This is the time, ladies and gentlemen, where Maxwell Anderson is removing Sade's body from his house, taking her to the car. It's now time to get rid of her, and he's got to do it in her car. He needs the car away from his home. He needs to get rid of anything that's going to tie her back to his home. He needs that car gone. He needs her gone. 12:47 a.m. is when we see the car leaving the house, going southbound, exiting onto Euclid, and from there you saw an exhausting amount of videos showing the car driving away from his house, northbound to the north side of Milwaukee. That was 12:49, 12:51 going northbound on 35th Street, passing Badger Ham. 12:53 a.m. northbound, passing 35th and Greenfield. And eventually, we get the exact route that is taken when we get the phone records. He drove northbound on 35th, he went to the downtown area, and he ultimately exited the interstate just prior to 1 o'clock a.m. Remember, this timestamp was off by about 2 minutes and I thought it was 2 minutes, 40 seconds or so that the detective said. That is her car. We know it's her car because this camera happens to have a license plate reader. And that license plate reader is putting her on that exit ramp downtown at the exact same time that her phone, her Life 360 and Verizon records show that that car would be exiting at that same time. What can you conclude from that? You can conclude that her phone is in that car. She's in that car. Someone's driving that car. It's Maxwell Anderson. Continues to drive. He goes up Commerce, passes by her apartment building. I know something of defense was trying to make some note of it. They never stop at her apartment building. There's no evidence that that happened whatsoever. And the detectives reviewed hours and hours of video footage from her apartment building to ensure that that car never came back and that Sade never came back to the apartment. He didn't stop there, and these records confirm that. What does he do? He drives the car with her body up into the River West area by about 1:33 a.m. There he is at 106, driving her past Commerce Street, passing Lakefront Brewery. And then he heads into River West. You saw the video of the car in River West off of Dowsman near Pleasant Valley Park along the Milwaukee River. And what do we know happens while he's out and about driving around? His phone dies. He leaves his phone behind. That was done on purpose. Because look at all the records we have showing where her phone traveled and where his phone traveled before this time. He left it behind to cover up. That's why he did that. And we know that because we looked at it, and you heard from the analyst today who said that all activity on that cell phone stopped after 12:08 a.m., right after he's deleting pictures of Sade Robinson on his phone, of him grabbing her. Phone dies at 1:35 a.m. while he's driving her car around trying to get rid of her and trying to get rid of the car. He goes down Capitol. You saw the two videos showing the car going down Capitol. He doubles back towards the interstate. And by 2:20 to 2:25, he's back on the interstate heading back towards downtown. He eventually goes down through downtown on Interstate 94, ends up heading sort of west over to Greenfield, and then he comes back. And where do we know that he's heading at this time? He's heading to Warnemont Park. The phone records show that between 2:34 and 2:39, he's on the interstate, getting off on College Avenue. We saw the video of him exiting on College Avenue, and you saw the video of the car going through the airport tunnel in the direction of Warnemont Park. No stops being made, by the way. 2:51, he's passing by St. Luke's Hospital, going north on Lake Drive, all in an effort to ultimately end right here, Warnemont Park. Keep in mind what Agent Reinerth testified to, the 4 dwellings that Sade Robinson's Life 360 showed. There were 4 of them. Twisted Fisherman, her own work, or excuse me, Twisted Fisherman, Dukes on Water, Maxwell Anderson's house, and Warnemont Park, where she ends up. And her phone stays there for over 2.5 hours. Excuse me, an hour and a half. 2:52 is the arrival time, 4:33 a.m. That's the time the phone is there. We know at 2:52, her car is passing by the water department. And by 2:53 a.m., this was one of the first videos we saw, there's the Honda Civic going down Pulaski Avenue, going down the service road and ramming the gate to get down that service road, that steep road that you saw a photo of today when Chloe Wright was testifying. Why ram the gate? He knows how to get down there without ramming the gate. You saw a photo of the place, the way that they would walk down. You ram the gate because there is a body in the car that you have to get rid of, that you can't carry. He rams the gate. We know it's using her car because the crime lab fitted the broken pieces of Honda back to her vehicle. No question about whose car was used to ram that gate. It was Sade Robinson's Honda Civic. From 2:52 to 4:30 a.m., like I said, the phone remains in that location. What is that location? That is Maxwell Anderson's secret beach. It's the place, of all the places in Milwaukee County to go, of all the places to go, Sade's body ends up at his secret beach. He chose that location on purpose. You heard the reasons why today. It's secluded. He didn't even want to tell Chloe Wright what the name of the place was. He wants to keep it to himself. And you've seen the photos of it. You've seen how high those cliffs are. This is the middle of the night on a Monday into a Tuesday in a rainy early April evening. No one's going to catch him in the act. It's pitch black down there. It's the perfect place in his mind to take her to accomplish this, because he knew he had work to do. He needed to cut her up and get rid of her. So he takes her to a place he knows and a place he trusts, a place he knows he's not going to get caught. You saw the videos of the person who we now know as Maxwell Anderson ascending and descending the bluffs on the north side of the pump house, the side where her leg would later be found on April 2nd, going up the exact paths that Chloe Wright told you they would take to go down there and hang out. The exact paths. This is the time, ladies and gentlemen, where he is cutting up her body. She is dead. Now it's time for him to get rid of her. So that's where he goes. He takes her to his place. You saw in the video when he's coming up the bluff at 4:26 a.m., he's down there for over an hour and a half. And in that time, you heard gruesomely all that was done to Sade. All the cutting, the blunt force trauma to her bones, all of it done to get rid of her, to make her disappear. That's what he wanted to do. That's what he tried to do. And he did it in this time frame, from about 3 a.m. when he got there to 4:30 when he left. Now it is time for him to get rid of her car. So what does he do? 4:34, he drives her car out of Warnemont Park. We know he heads northbound on Lake Drive. We know that because Sade's phone is still in his car. Here's the record showing the direction of travel. From the site where the leg is found, her body is dispersed, headed northbound on Lake Drive, westbound on Howard Avenue here until the phone goes off the network. There's the video of him going by. And there's the last clip before it gets to the north side. And by 4:50 a.m., it is at 27th and Wells, where you can see the driver is a white person. You can see that in this video, and you can see how fogged up it is, and you can see how there's something covering the back window. He then drives north, circles the area of 32nd and Vliet, tries to go down this dead end near 34th and McKinley, but activates a ring light, so he decides, I gotta go to a different place than this. There's no reason for him to drive down that street. Circles around until about 5:20 a.m. when he goes off camera and reappears at 6:50. And it is at this point, ladies and gentlemen, that he is in the 31st and Galena playground. This is the area where her leg is found, her left leg. That gap shows that during that time period, he went into that playground to dispose of her leg. By 7:30 a.m., you You saw the video of him walking away from the burning car, where we now know from the crime lab he used an ignitable petroleum distillate to light the car on fire. And he walks away. And the trail of videos capture him walking southbound on 30th. He goes down Walnut Street. Trail of videos captures him all the way at 8:12 when he boards a Milwaukee County Transit bus, where his face is clearly visible, clear as day, and he's wearing a hoodie, that gray hoodie that would later end up in a dumpster 2 houses down from his. Tried to get rid of it, but he didn't. They found it. And whose DNA is on the hoodie? That is not the hoodie he's wearing on the date, by the way. That's the hoodie he's wearing after he has just dismembered a body and burned a car. And whose DNA is on it? His and Sade's. What are the chances of that? It's because he did it. It's because he's responsible. And he takes the bus home. He sits there, not a single time pulling out his phone. Why? Because he left it back home on purpose. And then by 8:42, walking in his back gate with that massive backpack that we have never found. He got rid of it. And whatever else was in it and whatever else was used, he tried to get rid of everything. He tried to cover up. And what does he do after he gets home? He powers up his phone and he sends a text. Morning, how's work going? Disgusting. Right after he's just burned her car, killed her. Why did he do that? He's covering up. He's trying to cover his tracks. He's trying to make sure everything seems normal. Same reason he went to work that day. Couldn't let his routine go out. He needed to maintain appearances, despite the fact that in the middle of the night, he's out cutting up a human body and burning a car. And by 5:29, Sade's leg is found on April 2nd. By 9 p.m. that day, she's reported missing, and the welfare checks begin. By 1 p.m. on the 4th, Mr. Anderson's arrested. And we know that in the subsequent days and month later, April 18th, May 11th, additional body parts are found. Her head, her right breast have never been found. He succeeded in getting rid of those. That's what happened. Those are the facts. That's what the evidence showed. Now you have to decide, based on the law given to you, the crimes. I want to focus on the homicide count. There's 4 charges. Numbers 2, 3, and 4 are pretty self-explanatory, and you have them in writing. Mutilating a corpse, hiding a corpse. Counts 2 and 4 are essentially the same elements. Count 3, the arson, pretty self-explanatory. But now you're given this first-degree intentional as well as first-degree reckless homicide. First-degree intentional homicide has 2 elements that I have to prove. I have to prove that the defendant caused the death of Sade Robinson and acted with the intent to kill. While the law requires that he acted with the intent to kill, it does not require that that intent exists for any given period of time. In fact, it says it may be formed at any time before the act, including the instant before the act. And you're also instructed that intent should not be confused with motive. While proof of intent is necessary, proof of motive is not. Motive being the reason why someone did something. That's not what we have to prove. We have to prove intent. And only if you don't all agree that he is guilty of first-degree intentional homicide, which I'm confident you will, do you even look at first-degree reckless homicide. The defendant caused the death of Sade Robinson, caused the death by criminally reckless conduct under circumstances that showed utter disregard for human life. Did he show any regard for life at all? No. So how do we know this was intentional? Everything you heard shows this was intentional. Consider all the things he intentionally did and the reasonable inferences from those actions. At 9:25 p.m., when Sade drives him and herself to his house, just the 2 of them, they went inside, and we know from before that she is coherent. She is not drinking excessively. She's in control of herself. But by 12:05, she is completely incapacitated, face down on his couch. and Anderson is grabbing her exposed right breast with no reaction from her whatsoever. He's pulling her pants down, taking photos while doing these things. This shows she was completely incapacitated, if not deceased, by that time. Consider all the acts to this point. He has her at his house, on his furniture, completely deprived of any strength or power over herself. He's then taking pictures and then intentionally takes her car and her and drives her away because he's now got to get her out of there, and he has to separate himself from her and her car. He drives with seemingly minimal direction, leaves his phones behind, brings with him a huge bag, some kind of a tool to cut up the body, takes her to a place he knows well. All done in the middle of the night. He takes her to Warnemont Park, cuts her body up, drives away, goes to the north side, goes to the 31st and Galena playground, discards her leg. He intentionally picks an abandoned building to leave her car behind, something that he has no connection to. Intentionally stuffs her clothing that she is wearing that night. The underpants literally pulled off of her body, still in the jeans when they're found partially burned in her trunk. Stuffs her clothes in her trunk. Uses a petroleum distillate to light the car on fire. All of that stuff was done on purpose. He then heads home, powers up his phone, and texts her. Everything about this is intentional. If it was unintentional, if it was anything else, you don't cut her up and do everything you can to get rid of her. If it was an accident, you get her some help. You don't try to make her disappear. And we know from the medical examiner, there is no other explanation. There was no natural disease, no toxicology reason whatsoever for this. If it was unintentional, he wouldn't have had the wherewithal to do everything he did so quickly. Think about it. In just hours, she went from literally driving a car to being incapacitated and him somehow being able to pull off, getting her to Warnemont Park and cutting her up. He's only able to do that if he knew what he was doing, knew how he wanted to do it. This only happens with the intent to kill. Consider what Dr. Karsten today and the medical examiner talked about, the amount of work done to break her bones and cut up her limbs and cut off her head. The efforts to cover this up were extraordinary and they were horrific. Consider the cutting off of her breast, her right breast. That's not something you do unless you have a desire to do it. It doesn't facilitate getting rid of the body. It takes additional time. He did it because he wanted to do it. All the stab wounds near her breast and on her torso. That was done out of a sick desire to do harm to her. That's the only reason that is done. Cutting off the breast, dismembering limbs, beheading her. Those acts, simply put, ladies and gentlemen, are the acts of a killer. They are not the acts of someone who is acting on impulse in a moment or acting on emotion. Who does this? What kind of person cuts someone's head off? A killer. A killer who's trying to get away with killing. His actions afterwards betray any innocence. That's how the evidence shows that what Maxwell Anderson did to Sade Robinson was an intentional homicide. There is no question behind the intent, and there's no question about the person responsible for doing it. The killer is him. He's the last person to be with her, the last one texting her, the last one whose residence she was at, the last one who had her car, the last one who had her phone, the last one who was with her. The one who burned her car. He did everything he could to try to get away with it. He tried to cover up. He tried to fool the police. He's trying to fool all of you, but he doesn't get to do that. You've all seen the evidence. It's time that you let the evidence speak the truth and you find him guilty.
Defense?
I'm going to take that down then. Or just close it. Good afternoon, everyone.
wanted to start by telling you what the purpose of closing argument is. It's, of course, my chance to speak to you. This is my last chance to speak to you as jurors. I don't get a rebuttal. The state does, so they still have an opportunity to come up here and speak to you again. This is the only opportunity that I have, and so I just wanted you to be aware of that. When I got up here in opening, it feels like ages ago now, it was 2 weeks ago when I stood up here and talked to all of you, and you've listened to a lot of testimony. I asked you to keep an open mind and to study the evidence closely. And I'm going to make the same request of you here today, tomorrow, when you deliberate, to study the evidence closely. You've been given a mountain of materials, and the judge has read a lot of instructions to you, and I want to talk a little bit about those instructions because as you hear Judge Crivello reading the instructions, it sort of goes on and on, but you're going to be given copies of those to take back with you to study closely and examine, and I ask that you look at those closely and pay careful attention to everything you heard in this case. The most important principle in the criminal justice system is the idea that a person can only be convicted if the district attorney's office has proven a case beyond a reasonable doubt. That principle has been with us for hundreds of years since the country was founded. The reason why that principle is so important is because it's crucial that when somebody is charged with the most serious of crimes, that we have absolute proof beyond a reasonable doubt by the district attorney's office, that when they decide to bring such serious charges against a person, that you are convinced beyond any reasonable doubt that in fact Mr. Anderson committed each one of these crimes. When Judge Crivello spoke to you, she talked about what reasonable doubt means. Reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or lack of evidence. So you can look at evidence as well as lack of evidence. It means such a doubt that would cause a person of ordinary prudence, meaning any of us, to pause or hesitate when called upon to act in the most important affairs of life. And of course, this is the most important affairs of life because you are deciding Mr. Anderson's guilt on, or whether he's not guilty on each of the counts. Another important instruction the judge had read is that each verdict, each count in this case, requires a separate analysis. And when I listened to the state's closing, I heard a lot about what their theory is with respect to intentional acts that they believe were committed after Sade passed away. I heard a lot about intentional acts that that Mr. Vance-Ferzan talked about in opening and again here in closing. But I want to emphasize that when you go back to the jury room and you evaluate the evidence, you are required to evaluate each count separately. And what the judge told you, what Judge Crivello said when she read the instructions a little bit ago, is that your verdict for the crime charged in one count must not affect your verdict on any other count. Why is that important? It's important because this is a highly emotional case, obviously. We all know that. We all know that it's that type of case. And we'll just call a spade. I mean, we have a victim's family sitting right here. We just heard them applause when the state finished their argument. I don't criticize them at all, what they're going through. It's not at all what I'm here to do. I can't even imagine it. Can't imagine it. But here's how the system works. We get 12 jurors together. We have 15 of you here, and you've been amazing jurors, all of you, here on time, ready to go, listen to everything. And what we try to do when we're representing somebody and representing Mr. Anderson is we try to pay attention to what's happening in court, but also all of you, because your decision is what really matters. It's not what Mr. Vance-Ferzan says. It's not what I say. It's really what all of you say once you go back in that jury room and carefully consider the evidence or lack of evidence. And it's important to evaluate each one of these counts separately. And the judge told you, as hard as that can be in cases like this, to try to check your emotions at the door. I know it's hard. I don't think any of us envy any of aspect of what our jobs are. We all have a job to do. The most important job is yours, and it's to check your emotion at the door, put aside passion, put aside prejudice, and look at the case from the evidence. That's all I ask you to do. And on each count, render a separate verdict unanimously. All of you agree. And there's a number of things I could say to you. The idea here is that each side is given 45 minutes. I don't know if I need 45 minutes when you've sat here and heard everything the same way I've heard everything and the same way the state has heard everything. We try to look at the jurors to see some people are taking lots of notes, some people are taking less notes. And at the end of the day, really it's just what you remember and what you ask to see. That's what counts. And you can ask to see anything. You can make a request when you go back there of the judge to view videos again, if that's something that you'd like to do, or look at DNA reports or look at photographs. You can make those requests, and I would encourage you to do so. And so I'm going to touch on some of the points that I think are important. You may agree with me, disagree with me, but this is my chance to present to you what I think are the important points in Max's defense. We do have separate crimes that are charged here. Obviously, if we broke them into sort of broad categories, there's the state's theory that Max intended to kill Sade Robinson. So that seems to be the glaring charge, of course, that is here. We also have charges of dismemberment, hiding a corpse, and arson of a vehicle. I'm not going to go through each of the elements of every one of these crimes with all of you, because that will go back with you to the jury room, and you can read those and decide. But we start with the fact that everything the state showed you in this case was that Max had met Sade. You saw the videos that were just played again in closing. The two of them met each other, and the two of them went out in public. They texted, they made arrangements to go out, and they went to places. When you watch the videos, they went to places that Max is known. Places where he was interacting in a friendly way with bartenders, where people were talking to him on a first name basis, where he's shaking hands with people, where he's having normal drinks, normal behavior. They go to Twisted Fisherman. They spend time there together. There's nothing in the videos that you've seen that suggests that Max is planning to do anything like an intentional homicide. There's nothing in the text messages that even comes close to suggesting that. Because of course, intent does have to be formed at some point, as they just said, and as the judge told you, before a person passes away. Nothing about the Twisted Fisherman video shows for 1 minute an intent to kill. And the same is true with Dukes. They go there, they're sitting at the edge of the bar, they're playing beer pong with another couple that shows up. Again, you can see, even if you want to watch the video again, you can see when Max leaves, he's saying goodbye to people that know him. Obviously, he used to work at Twisted Fisherman, we know, because he had to pick up his W-2 there. He's known at Dukes. So this is not any evidence at all that Max intended to kill Sade. And like many people do, they went out after drinking and they went back to his house. We asked you in jury selection, all of you, we asked the question of whether or not you would insist that a defendant testify. The defendant has a constitutional right not to. That's a hard principle for some people to embrace. You don't have to testify. The system doesn't require that. It's human nature. It's to want to hear sometimes, you know, like we say to our children sometimes, what did you do? What happened? Give me the side of your story. But that's how we handle things in our personal lives and not what is required here in court. And I am just going to address the elephant in the room. Max didn't testify, right? We all saw that. And maybe some of you were thinking to yourselves that you wanted to hear from him. Maybe all of you were thinking that. Certainly members of the public might have been thinking that. But he's not required to do that. The judge told you that. He's not required to give any explanation or prove his innocence. System does not ever require a defendant to prove their innocence. It requires the state to prove that he intentionally killed her. I didn't see any evidence of intent when I sat through this trial. The state points out things that they say Mr. Anderson did after the fact, which would demonstrate, if he had done it, an intent to commit other crimes, mutilation of a corpse. But I didn't see anything, and I listened carefully, and I know all of you did too, that shows any intent to kill. And that's how it started, and now there's a reckless homicide charge that you're supposed to consider as well, but I didn't see or hear any testimony about Mr. Anderson acting recklessly towards Sade at all. And those elements have to be proven. It has to be proven. in words, as the jury instruction said, words, actions, behavior before the event. Well, what are they pointing to? I'm asking that question. What are they pointing to? They're pointing to things afterwards that they say Mr. Anderson did, which they want you to bootstrap into a conviction on an intentional homicide. But that's not what the law says you're supposed to do. The law says that you're supposed to look at each count separately. The law says that a defendant doesn't have to prove his innocence. The law says that they have to prove intent or recklessness beyond a reasonable doubt. The highest possible burden you could imagine. Not just that we think he might have done it, or last person with her could have done it, but that he intended to do it, or that he did it recklessly. And I don't know, based on this record, candidly, how she died. I don't know that any of us do. The medical examiner doesn't. Medical examiner's unable to tell us that answer. It's their job. Certainly the anthropologist we heard from doesn't know. And I talked about this with all of you in opening, that they have the burden to prove everything beyond a reasonable doubt. And if they don't, we don't have to put on any evidence. We don't have to put Max on the stand. We don't have to call witnesses to say A, B, and C. And I told you in opening, we weren't going to dispute, I forget what I said exactly, but I probably said we won't dispute 90+% of the case, because we don't. Everything Mr. Vance-Ferzan just showed you about the vehicle traveling to these locations, we dispute the big things, that it's Mr. Anderson intending to kill her or recklessly kill her. We dispute that he committed the other crimes, but the fact that they went on a date, the fact that they were together, the fact that they were friendly with each other, they drank, no dispute. The vehicle being shown on camera all over the place, the locations it went, no dispute. What we do dispute are a number of important points that I don't think have been proven. You never once see Max getting into this Honda Civic. Nor do you see him getting out of the Honda Civic. You don't see him get in and you don't see him get out. And there was a video that was played very early on in the trial that all of you will remember because it was day 1 or day 2, but there was a video of the Honda Civic when it is in flames, basically on Lisbon Avenue, if we all remember that. And there's 2 women on the street who are on tape pointing in that direction. And you can obviously see that Max is in that area. I told you in opening, sometimes people can be in the wrong place at the wrong time. I don't have to prove, I have no burden to prove why Max was in that area. That is burden shifting, is not required. They have to prove that he was the one that exited the driver's door of that car and lit it on fire. They did not call either of those women in their case. They could have chosen to call either of those 2 women on the street and put them on the stand and say, is that the guy who lit the car? Or is that the guy walking near the car? Big difference. They could have asked him any question they wanted. Of course, we would have been able to ask questions too, but they could have put, her name is Laura Dyer, you heard that through other witnesses. They could have put Laura Dyer on the stand and asked her, who were you pointing to? What were you seeing? What did you observe in the minutes leading up to that? Who got out of the car? What side did they get out of, ma'am? What side did they get out of? If they got out of the car, how did they light the car on fire? They could have asked all of those questions and answered all of those questions for you. And we know for sure that she was shown a photo array because I asked one of the detectives about the photo array procedure. We know for sure it was shown, and they didn't introduce it. I'm not here to hide a thing. Study it all. Study every piece of evidence that they gave you in this case. But they didn't call Laura Dyer, who I would argue would be the one witness you would call in your case if you wanted to prove that Max lit that car on fire, instead of being near it. And if we work from there forward, if we look at his behavior afterwards, Max's behavior, it's Max there, his behavior afterwards, they haven't proven what was in his backpack. But if we look at his behavior afterwards, he is not, as they just said, concealing his identity. Now, if you lit a car on fire, there's 4 ways you can go, north, south, east, or west. And I would argue that the last direction you would go is right down to Lisbon Avenue if you did that, onto a public street with cars whizzing by and buzzes everywhere and getting on a public bus. Actually, if you looked at the video, there's an alley right there. The more logical way to go is just dart up through that alley, get away. duck through houses and backyards and run. Max is walking. But look at his shoes, because their theory that they've given you in this case is that Max, prior to this, first of all, their theory is he killed her in his house without Pete Warburton hearing a thing, who's right below him. No struggle, no stabbing, no nothing, no help, nothing. But their theory is he killed her there. But then in the rainy day, pouring rain for days, muddy path down to Warnemont Beach, their theory is that Max did all of that. Why on earth, when he is walking on Lisbon Avenue, and you can watch the videos, look at the shoes. They're pure white soles, at least the sides. Even the detectives testified to that. His shoes are white. Somebody who has been trudging through the mud, dispersing body parts in Warnemont Park in the pouring rain, in the bad conditions, does not have white shoes. No way. Muddy shoes, for sure. Watch the whole bus video. He doesn't, as they said, he doesn't pull out a phone or he sits there the whole time. Shoes are white. That is inconsistent with somebody having been at Warnemont Beach earlier and doing all of these things just a few hours earlier that they say. The sweatshirt that was located in the trash can. We had some testimony a few days about that. I don't know what to make of that. I don't know if it was planted. I don't know how that sweatshirt got in that trash can. But I know that if somebody was trying to destroy evidence, they could burn it right in the backyard. There's a burn pit right there, and they would be unlikely to ditch it right in the alley 2 houses down from them. Seems like a really unlikely thing to do. But what you didn't hear about the sweatshirt, and we know it's found on April 12th. After Max has been arrested, he was arrested on April 4th. So 8 days later, they find this sweatshirt. And how on earth is a detective, I think it was Lopez, how on earth is a detective on April 8th? He told you his job was to go down this alley to look in the trash cans. Remember, he was going to go look for clothes or evidence. If you were going down an alley to look for clothes or evidence, and he's now telling you, I remember seeing a sweatshirt in a trash can, but I just left it there. His job was to look for a sweatshirt or any clothes. I just find it really hard to believe. I think he's not being honest when he says that. I find it really hard to believe that if you found a sweatshirt in a trash can when that was your job to go the alley behind Max's home, you would grab it. And the trash came through on April 8th. Max is in jail. And there is none of Sade's blood on that sweatshirt. We were just told, again, he's wearing that sweatshirt supposedly when he dismembered a human corpse. The amount of blood and bodily fluid that would require, look at the video of him on the bus. If you can see a speck, there's no gloves on him. There are gloves at Warnemont Beach, which exclude him, but there's no blood on him at all. There's nothing on his hands. He's not wearing gloves. Max's DNA is also not on the driver's door of Sade's car, which is lit on fire, but her DNA is. So if their theory is that the DNA on the car driver's door was washed off by the fire department, why is Sade's DNA there? And his isn't. It's because he didn't close the driver's door. It was in the wrong place at the wrong time. And they swabbed everything. It was really boring. Some aspects of the trial were really boring for all of us because you had to sit here and watch grainy videos of what a detective thinks they see upstairs, and you have to listen to us on our end bore you, unfortunately, at times by going through all of the DNA evidence. But for crying out loud, this was the most swabbed home I've ever seen in my life. Swabbed everything. Everything. Ask for the report. None of Sade's blood is anywhere in that home. But she's been stabbed. He doesn't have any blood on him at all for a stabbing. And they don't have any weapon that they can connect to him that he ever used for this stabbing. Or however she died, they don't know. But they do know for sure the DNA excludes him. It excludes him because her blood isn't in his home. Her DNA isn't anywhere in there. There's no smell of bleach. There's no indication he cleaned up. I would argue this does not look like a cleaned up place at all. Look at the photos. And there was a hair found on a proximal bone one of Sade's bones, the hair that was found, and they thought for sure that's going to be Max's hair. We have a hair on a bone. I guarantee that's why they tested it. And look at the report. The hair on one of Sade's bones excluded him. Wasn't his. The video of the house, there's look at the pictures if you want to. It's grainy, it's poor quality. I also heard Rachel Smith said she spent 100 hours or whatever she said about the quantity of hours looking at video. The reality about the video is, again, we don't dispute that Max and Sade went back to his house. We don't dispute that they were there. Which silhouette is what or what it shows, your guess is as good as mine. I know that the FBI could look at it if they wanted to, and was never asked of them to do that. They offer a witness with no specialized training in an effort to convict Max of homicide to say, well, I saw this silhouette and that silhouette, but they didn't do any height analysis. They didn't ask the FBI to be involved, and it doesn't show anything that we don't already agree happened. They were back together. But that front window was piled full of plants and other debris and miscellaneous things in there, so it's unlikely that there's really a whole lot of interaction you can truly see. It's probably dogs run around. I don't think Max is so sophisticated of a guy. I'm representing him. We heard from Pete Warbington. I don't know that Max is the most sophisticated guy out here. He's a smart guy, but he's working 3 days a week. He's a bartender. And Pete Warbington says, I complain about a hydraulic arm. He won't fix it. And Max doesn't like hearing that he's a bad landlord. I know. But the reality is that he's not a highly sophisticated guy where they introduced all sorts of evidence of his planning and research on wanting to kill someone. 30-some years living in the area, working for a decade as a bartender, well-known throughout the city. They didn't introduce one weird thing about him. No psychological profile evidence to show you that he fits the pattern of someone who's going to just decide, I'm going to kill someone tonight after a date where I went everywhere that everybody knows me, and I've never researched it, and I've never looked into it, nor have I even so much as looked at how to dispose of a body or remove body parts, which you can only imagine what kind of feat that is. Use your common knowledge of even examples you can think of cooking about how hard it might be at Thanksgiving to remove a turkey leg, let alone a human. No research on it, no planning on it at all. Again, that's because he didn't have any such plan to do anything like that. It's not that secret of a beach either, if I can just say that. I mean, a few hours after someone is down there in the rain and the horrible conditions, there's 2 kids there a few hours later in that same spot, right? They're there. They find a bone or a leg. So it's not that secret. It's Warnemont Park. It's a public park, 18-hole golf course. Everybody in the community is familiar with that area. Officer Desmet testified, very familiar with the park. People go there all the time. We have 2 youngsters there right away a few hours later finding human remains. So not exactly a secret area that nobody's ever heard of before. What is Max's behavior afterwards? A lot of times in our human affairs, and Judge State has told you, use your common sense. The reason they keep saying common sense, and again, I didn't tell you not to use common sense. I talked about this in opening. Go ahead and use it. Use it galore. But also, please look at the evidence. You have to do more than just base things on this expression, common sense, okay? Look at the evidence. We do know that somebody who committed a crime like this, who had done something like this, when they haven't, would be highly likely to change something about their life. He didn't do any such thing. He continued to go about his day-to-day affairs. You heard that he went to work at Dugout 54 the next morning, and his phone died, not turned off intentionally. It died during the hours that one would be asleep. And he went to Dugout 54, and he worked at Dugout 54, which was his job, the next day. No issue. You didn't hear from one person who said that suddenly his behavior was different or that he started acting strange. He continued to work, stay in the area, didn't cut his hair, didn't change his appearance, didn't have a whole pile of cash in his car with a passport to Mexico, none of that. just going about his day-to-day affairs. That's because he's innocent. And the police are the ones who make a decision on what to collect and what not to collect. And they give you that evidence, and then you decide whether it is proof beyond a reasonable doubt. They could have asked for more footage if they wanted to see what was going on the side of Max's house in the days after, or the alley in the days after. Does he ditch a sweatshirt in a trash can? But they chose not to, because they zeroed in on him, they zeroed in on a time frame, and that was all they needed to do. I know that when the evidence shows that when Sade's car left Max's house, and you never see him driving that car, when it left that house, and we know things can happen in an alley, when the car left that home, it went straight to Sade Robinson's apartment building. I never said it went there, to be clear. I never said she went in there. I'm just saying, what are the odds that with no evidence he even knew where she lived, that Civic goes from his home right past the building she lives in? A hell of a coincidence. I think it's very likely that perhaps something happened to her in the alley and perhaps she was directing them where to go. I don't know, but I do know maybe it was a stalker. But whoever did it obviously had an idea where she lived because they went right from point A to point B. I think the reason that the state spent such little time talking about the DNA evidence for you is because they know how powerful it is for the defense case. But we don't have to prove that DNA proves prove his innocence. They have to prove beyond a reasonable doubt that he's guilty of each of these crimes, that he intended to kill her. Now they're saying recklessly, but either one, whichever one they're saying. They had to form that intent or that reckless decision before. There's no evidence, by the way, of any reckless behavior at all that they've shown you on video, that they've shown in his house, that they've shown at all. But the reason why they spend so little time on DNA and they sort of brush past that, and yet they'll spend days and days and days going through monotonous video of things we don't dispute, is because they know that the DNA evidence is powerful for us. And I ask that you look at the evidence closely. That's all I can do. I turn Max over to you. It's your decision. You have to look at each count carefully, and I'm convinced you'll conclude that the state hasn't met its burden of proof on each count. Thank you.
State, any rebuttal?
Sure. Ladies and gentlemen, the reason Maxwell Anderson went to work the next day and didn't cut his hair or do any of that stuff is because he thought he got away with it. Because he did it alone, he did it in the middle of the night. So leaving town, doing that stuff, that brings attention to yourself. That's also why he sends that text message to her the next morning. Hey, morning, how's work going? He's trying to cover up. He thought he was gonna get away with it. That's the whole point. Because everything he did the night of this incident was done in the middle of the night in a secluded place that he knew was secluded, that he took her to and cut her up. He thought he got away with it. Let's talk about blood. You saw the images of her on that couch. She's out of it. She is gone. There's no blood in there. You heard from the medical examiner how people can die without blood. Strangulation, suffocation. It's no coincidence that she is face down in his cushions in those. That she is so out of it that he's able to lift her shirt up and grab her breast and yank her pants off without her putting up a struggle. We know as well that the dismemberment, remember the medical examiner talking about the vital reactions, that there were no vital reactions at the areas of amputation. That means no bleeding because she was dead when it happened. And he's doing it down at the lakefront on the shores of a lake on a rainy night. And he talks about no mud, no blood on the shoes or anything like that. He's got this massive backpack with him. that he gets rid of, that has never been found. Why? If that backpack is something that's important enough for you to go out in the middle of the night with, why is it gone? Because he got rid of it. He got rid of it to cover up the crime. The hoodie, why is it in someone else's dumpster? Why is the hoodie not a hoodie you were wearing while on the date, but a hoodie you're driving around in the middle of the night with? Why is it in a dumpster 2 houses down? Why is her DNA on it? It's because he's the one driving her car around, taking her body to Warnemont Park. No intent to kill? What about all the horrible, disgusting, gruesome things that he did to her body? That shows intent to kill. He brought up this hair on the proximal bone, and his argument was Max was excluded from that hair. Do you remember whose hair that was? It was Sade's hair. He failed to mention that part just now. Just like he failed to bring up the latex gloves he brought up in his opening and said, certainly these gloves played a role in this crime. That was a quote. What a joke. Those gloves had nothing to do with this crime. Nothing. The blood on those gloves was neither Max nor Sade's. It's located a quarter-mile south of where this occurred. A week later, a smoke screen. Nothing to do with this crime. Maxwell Anderson was not walking away from the Honda Civic because he's in the wrong place at the wrong time. Why on earth is he walking around behind an abandoned building where the woman who he was on a date with the night before's car is getting set into flames, and he's just casually walking away? And you did hear from the woman who saw him do it. You heard her on the video. You saw her point to him and say, he did it. Call the fire department. What's that all about? It's because he's the one who lit the car on fire to cover up all of this and calmly walk away because he's trying to get away. He's trying not to draw attention to himself. Asking you to completely speculate that something happened to her in the alley. Well, let me ask you this. How does she get in the alley if she's passed out of it, incapacitated on his couch? How would she have even gotten there? He's asking you to speculate. She's just instructed you, you can't speculate. You are not to speculate. That's what he wants you to do. That's what he wants you to do to find Maxwell Anderson not guilty, but you can't. You follow the evidence. Not a single piece of evidence points to anybody else. Everything at every single turn, even when police tried to focus on other things, like the latex glove, did it lead anywhere else except back to him? The broken pieces of car at the gate just happened to match the Honda that he's walking away from as it lights on fire. The beach where she is cut up, it's his beach. It's his place. Every single lead, every single thing the investigators did led back to Maxwell Anderson, and it is because Maxwell Anderson is the killer. He is responsible, so find him guilty.
Now, members of the jury, the duties of counsel in the court have been performed. The case has been argued by counsel. I've instructed you regarding the rules of law which should govern you in your deliberations. The time has now come when the great burden of reaching a just, fair, and conscientious decision of the case is to be thrown wholly upon you, the jurors selected for this important duty. You will not be swayed by sympathy, passion, or prejudice. You will be careful and deliberate in weighing the evidence. I charge you to keep your duty steadfastly in mind and as upright citizens to render a just and true verdict. You are to decide only whether the defendant is guilty or not guilty of the offenses charged. Any consequence of your verdicts are matters for me alone to decide and must not affect your deliberations. There will be 9 forms of verdict submitted to you regarding the charges against the defendant. As to count 1, there will be 3 verdicts. The first verdict reads, we, the jury, find Maxwell Anderson guilty of first-degree intentional homicide as charged in count 1. Another reading is, we, the jury, find the defendant Maxwell Anderson guilty of first-degree reckless homicide in violation of section 940.02 sub 1 of the Criminal Code of Wisconsin at the time and place charged in count 1 of the information. And a third reading, we, the jury, find the defendant Maxwell Anderson not guilty. As to count 2, there are 2 verdicts. We, the jury, find the defendant Maxwell Anderson guilty of mutilating a corpse as charged in count 2. Another reading, we, the jury, find the defendant Maxwell Anderson not guilty of mutilating a corpse as charged in count 2. As to count 3, there's 2 verdicts. We, the jury, find the defendant Maxwell Anderson guilty of arson of property other than a building as charged in count 3 of the information. Another reading, we, the jury, find the defendant Maxwell Anderson not guilty of arson of property other than a building as charged in count 3 of the information. Lastly, as to count 4, there's 2 verdicts. We, the jury, find the defendant guilty of hiding a corpse as charged in count 4, and another reading, we, the jury, find the defendant not guilty of hiding a corpse as charged in count 4. You are to bring in 1 verdict per count. It is for you to determine whether the defendant is guilty or not guilty of each of the offenses charged. You must make a finding as to each count in the information. Each count carries a separate crime, and you must consider each one separately. Your verdict for the crime charged in 1 count must not affect your verdict on any other count. Now, this is a criminal, not a civil matter. Therefore, before the jury may return a verdict that lawfully may be received, the verdict must be reached unanimously. In a criminal case, all 12 jurors must agree in order to arrive at a legal verdict. When you retire to the jury room, select one of your members to preside over your deliberations. The presiding juror's vote is entitled to no greater weight than that of any other jurors. If you need to communicate with me while you're deliberating, have the presiding juror send a note, time-stamped and signed by the presiding juror with your question. It may take some time to answer because I may consult with the attorneys before I respond, so you should continue your deliberations while you're waiting for a response. I will answer all of your questions either in writing or I'll bring you back into the courtroom and answer them on open record. When you've agreed upon your verdict, have it signed and dated by the presiding juror. Notify my bailiffs that a verdict has been reached. Everyone will return to the courtroom and your verdict will be read into the record in open court. I may ask each of you if you agree with the verdict. 4:37. I think we'll begin the deliberations. Okay. At this point, we're going to select our 2 alternates. So, 3 alternates. So all of your numbers are inside of this box. Juror number?
53.
Who's 53? Okay. Your first alternate?
38.
Second alternate?
And the last one, 26.
Okay, the 3 of you are my alternates. So at this point, your service is complete for the next 4 years. If you need a notice for your employment that you've been here with us, you'll have to go back to jury management to get that. Otherwise, it'll come out to you in the mail in about 2 to 3 days. Now, you're not allowed to speak to any of the other jurors, but after you leave here, you're free to speak to anyone that you wish or to no one. It is completely up to you. If you wish to return to the courtroom and wait for the verdict, you're welcome to. If you want to call my court at a later point and find out what happened, you're welcome to as well. Or you're welcome to check CCAP. Now, do the 3 of you have anything in my jury room? Okay, I need to release the 3 of you before I release the other jurors. So thank you for your time and attention and service. I've used alternates way too often, so I appreciate you being here. You're not allowed to communicate with the other jurors at this time. At this point, we will swear the bailiffs.
Do you solemnly swear that you will keep jurors on this trial together in some private place and that you will not, before they render their verdict, communicate the state of their deliberations or the verdict they have agreed upon? So help you God?
I do.
Thank you.
Okay, you may begin your deliberations. Any objection as to how the jury instructions were read into the record, state?
No.
Defense?
No.
I did find on the jury instructions one correction, which was on the last page relative to the verdicts. It said 4 verdicts will be provided. I changed it to 9, and I just wrote it on it. So that was